Well, good evening. This is the last of many sessions of our work. Let me, as we always do in our arbitration hearing, first introduce my colleagues. On my left, I have Professor Martin Hunter, and my right, Mr. James Hoskin, and by way of invitation, you may have guessed that I'm Karl-Heinz Beck-Schiedel. So this is correct. I would be grateful if the four representatives of the parties would just let us know their names at this stage. Start with the claimant.
I'm Aaron Matthews. Jonathan Matthews. Oh.
My name is Marina Sotnikova.
And Anton Petrov.
Thank you very much indeed. Now, we have a limited time, as we all know, and my first question would be, have the parties been able to agree on their timing and the order in which they want to plead?
Yes, we have.
Why don't you tell us?
We will start with respondent on jurisdiction, followed by claimant and rebuttal, rebuttal, then claimant on merits, followed by respondent on merits and the rebuttals.
Very good. That would have been what we would have suggested anyway. So we have an agreement to start with, which is nice. So this is the agenda we have before us. You know the time limits you have. We have a secretary, supervisor, who will let you know when you come close to your time limits, so that you can organize your final words. And in that way, I'm sure we can finish within the time that we have for this session, which is 90 minutes, as you know. All right, having said that, have I forgotten anything? May I ask my colleagues? Not yet, which is nice. Okay, so we'll start with the respondent on jurisdiction.
Respected members of the tribunal.
Get close to the microphone, please.
Good afternoon, respected members of the tribunal. My name is Marina Sotnikova, and today, together with my co-counsel, Anton Petrov, we represent Commonwealth of Begonia, respondent in this dispute. Now we'll start with procedural issues of the case at hand. After that, my colleague will follow with substantive parts. We state that this tribunal lacks jurisdiction due to non-compliance with both principles, ratio persona and ratio material. Now I will start with my first submission. Another company is Bergonian national, and thus, in order for this tribunal to have jurisdiction over the dispute, it should establish that Bergonia consented to treat Petersburg as foreign national, and moreover, this company met objective criteria of foreign control under Article 25 of Exit Convention. We state that Petersburg company fails to meet either promise to front test. In accordance with Article 1, Bergonia Convenienza Deity, nationality of a legal entity should be determined by its seat. In the present case, Petersburg company has its seat and incorporated in Bergonia, and thus this company is in strong accordance with the definition of Bergonian national under Bergonia Convenienza Deity. So there is now consent of Bergonia to treat it as foreign national in the name Deity. Petersburg company seems to rely on Bergonia Tertia Deity by virtue of most favored nation clause. However, Bergonia states that this most favored nation clause could not be applied to dispute settlement provisions, and in any way, it could not extend the jurisdiction of the tribunal. It could not extend the consent of the parties to arbitrate. To prove this position, we would like to analyze and interpret the most favored nation clause in the present case. We firstly like to draw attention of the tribunal that there are different types of most favored nation clauses in practice. Some of them we can call wide or broad most favored nation clauses. For example, we can find it in Mapizini case, and the wording of that clause is all matters. In the present case, we have a narrow most favored nation clause. And the example of such clauses, for example, we can find it in Plama, in Wintershall, in Telenor case. I can even quote it. For example, in Telenor case, we can find that most favored nation provisions shall be accorded treatment no less favorable than that accorded to investment made by investors of any third state. And if we look on the Article 3 of Bergonia Convenienza BIT of the most favored nation clause in the present case, we can find that most favored nation provisions is also treatment less favorable than the course to investment of investors of any third state. So the wording is the same. In all that cases, and in Telenor cases, case 2, the tribunal find that there is no jurisdiction since dispute settlement provisions could not be included in most favored nation clause within the wording treatment. Moreover, in the present case, most favored nation clause is specified by a list of examples in Article 3.3 of the Bergonia Convenienza BIT. All that examples belong to one kind, to the kind of substantive rights. For example, access to raw materials, marketing of products, and so on. It reflects the view of the parties that the word treatment should be interpreted as treatment of substantive rights. And there we ask the tribunal to apply used in generis principle, which states that if the phrase is followed by a list of examples all belonging to one kind, then the whole phrase should be interpreted as to belonging only to such kind. Even if the tribunal finds that dispute settlement may be as a part of friendly investment climate could be included in the most favored nation clause, then we still state that there could not be extension of the consent of the parties. There, it is relevant to say that consent is the foundation of arbitration, and that is not theoretical approach, that is not hypothetical words, that is that thing from which the power of the tribunals, the jurisdiction of the arbitrators to resolve the dispute is derived. So in every particular case where the question of extension of the consent is arise, we should analyze all the facts of the case and to find that there is no doubt that the parties intend to extend the consent in other bilateral investment treaties.
May I ask you a question in that context, relating also to what you said in the beginning? You mentioned the most favored nation clause, and I understand you say it's narrow, so it doesn't cover the jurisdiction. But now you turn to consent and say that's relevant. We all agree, I think, on that. But if you have a consent as indicated in a certain BIT, as here, and then you use the most favored nation clause, isn't that a consent between two other parties that you refer to, and that therefore by definitio goes beyond the consent of the original BIT parties?
My position there is that I do realize that maybe tribunal could apply dispute settlement provisions in most favored nation clause. However, the part of the dispute settlement provisions is the consent which is given by the parties. And in this part, it in any way could not be included in this most favored nation clause. Since there was no consent of Bergonia to treat members as foreign national, there was no also intent to extend the consent from Bergonia Convenienza bilateral investment treaty to the other treaties. Okay, thank you. Just to conclude this submission, we would like to point out that the question of the extension of the consent in any way, that is the exception from the general principle, and thus we state that exception should be based on exceptional circumstances, which are not presented in the present case. However, even if this tribunal finds... Yes?
Can you give me an example of the type of exceptional situation that you think would apply?
Yes, I could realize the type of exceptional situation where, for example, in tax activities of the company, the state is somehow shown that this company is controlled as a national of another state. And maybe it gave some privileges to this company or something like that. Or maybe the wording of the most favored nation clause was other. So in that case, there could be an exception from the original consent should be given in the BIT. Okay. Even if this tribunal finds that Bergonia BIT should be applied in the present case, we still state that consent which was given by Bergonia in that BIT could not be applied with respect to member company, since Bergonia properly exercised the right to deny the advantages of the treaty with respect to member. Article 1.2 of Bergonia Chapter DIT provided that each party reserved the right to deny to any company the advantages of this treaty if nationals of any third country control such company. In the present case, Melbourne Company is controlled by MedScience and Dr. Frankenseed, which both nationals of a third party. So Bergonia has the right and properly exercised its right to deny the advantages of this bilateral investment treaty. We do realize that usually this denial should be done prospectively, as it was noted in Plummer case. However, in the present case, the situation is different, since in the present case, Bergonia has no other opportunity to deny the advantages of the treaty earlier. So this country exercised its right immediately after the request to arbitrate.
For a moment. Seek clarification to help me on the point. The question of control, how far back is it appropriate to go? Clearly, MedScience is 100% controlling party of the claimant.
Yes, sure.
And then but if you start to go back from there, how far can you go back in terms of control, and why?
Surely the question of the control is our other submission, and I will just now proceed with it to make it clear. So in the present case, as we said, MedScience and Dr. Frankenseed should be treated as controllers of Melbourne Company. And as far as I understand your question, if I understand correctly, how far we can look on the indirect shareholders? Yeah, that's the question. Well, our position is that far, which is necessary in our present case. We say that in that case, Maddox is a shell company, and this is just a formal structure between MedScience, Dr. Frankenseed, and Melbourne Company. So even if we could find that MedScience and Dr. Frankenseed also may be a kind of formal structure, then we should go far and far. However, in the present case, it is not necessary since MedScience and Dr. Frankenseed are actual controllers. And actually, that is following me to my second submission with respect to foreign control. And first, with that, I would like to point out that there is no presumption in this tribunal finds that the consent was given. Then we still say that we should prove the objective criteria of foreign control, since there is no presumption, because the consent was given in bilateral investment treaty, as Professor Schroer mentioned in his commentary to the Convention. Only in cases where the consent was given in specific agreements, it arises the presumption that there was a foreign control. However, in the present case, we should prove it. And we could not do it, since, as I said, Melbourne Company is controlled by MedScience and Dr. Frankenseed. In order to be deemed under foreign control with respect to Article 25 of the Exceed Convention, the company should be controlled by nationals of other Exceed contracting parties. So it is not strictly established in the Exceed Convention, however, it follows from the drafts to the Convention, from the subsequent practice, for example, from Saudi case. And there, MedScience is Laputa national, and Laputa is non-Exceed contracting state. And Dr. Frankenseed is Bergonia national, since dual nationals were in accordance with the Exceed Convention should be treated as a national of the respective host state. As I said, answering your question, Maddox Company is a shell company. We proved this position on the fact that firstly it was established like CC123 Ltd. Moreover, we would like to draw the attention of the tribunal that Maddox was acquired by MedScience and Dr. Frankenseed in December 2003, and in January 2004, Melbourne Company was established. Moreover, Maddox has just two employees, tax advisor and a lawyer. We state that tax advisor and the lawyer could not exercise the control over the large pharmaceutical company's Melbourne Company. However, we should look on the actual controllers. It is proved by, for example, TSA case, by cable TV case, and by vacuum salt case. And in vacuum salt, there was a substantial analysis of the category of foreign control. And And there I will add the submission that 100% of ownership is not sufficient to automatically prove that the foreign control existed in the case. Foreign control is a complex question, and we should look actually on the control, but not on the participation in the stock of the company, and on the managing of this control. As I said in the present case, we could not even imagine the situation where the lawyer and tax advisor control a pharmaceutical company. However, we can clearly imagine the situation where the one pharmaceutical company, Mad Science, is controlling another pharmaceutical company, Mad Company. So in the present case, Mad Science and Dr. Pharmacy are actual controllers, and thus Mad is not under foreign control for the purposes of the exit convention. Now I'd like to proceed with my second statement with respect to non-compliance with ratio material principle. We all there know that this tribunal has jurisdiction only over the disputes which arise directly out of investment. However, there is no definition of investment in exit convention. But in the present case, we can find this definition in Vergonia Convenienza BIT. In accordance with Article 1 of this BIT, the term investment comprises every kind of asset invested and so on. We state that the key point there, the key phrase there, is the word invested. So we do realize that patents are named in the list of the assets which could become the investment. However, in the present case, the patent was not invested to Vergonia, it was never transferred to Vergonia. With regards to uncontested facts in Annex 3, in paragraph 5, we can find that this patent was issued by Vergonia itself. So this patent is not an investment of Vergonia, that is an asset. We do realize that claimant tried to rely on Vergonia Tertia BIT, and we also can find the definition of investment in that BIT. And in Vergonia Tertia BIT, the patents even are not listed in the name of the assets which could become the investment. So in any way, we have these applicable rules. Vergonia Convenienza BIT or Vergonia Tertia BIT, the tribunal decided. And may I just finish my sentence? Sure. And in both these bilateral investment treaties, in accordance with the provisions of these BITs, the patent in the present case is not an investment. Thank you for your attention.
Thank you very much. We'll turn to the table.
Mr. President of this Honorable Tribunal, my name is Aaron Eccles, and along with my co-agent, Jonathan Matthews, we represent Medberg, claimant in this matter. This tribunal has jurisdiction over this matter for two reasons. First, claimant is under foreign control, as required by Article 25(2)(b). And second, claimant's use of Vergonian patent number AZ-2005 constitutes an investment. Respondent set forth the jurisdictional requirements under Article 25(1) and Article 25(2)(b), so those will not be addressed here. Respondent also spends a significant portion of time refuting the most favored nation clause. However, that is only used in the alternative by claimant to establish jurisdiction. Here, as pointed out by my first point, claimant satisfies both criteria of Article 25(2)(b) for two reasons. First, claimant is a wholly owned subsidiary of MEDX, a conveniencia incorporation, and conveniencia is an exit contracting state. Second, there is an implicit agreement to treat claimant as a foreign national. Respondent advocates a test that requires us to move beyond MEDX's level of holding and look at MedScience as a controller. This is problematic for two reasons. First, as indicated in Tokyos Tokelos versus Ukraine, that test is typically only used in instances of fraud or to prevent an individual or a company from other misuses of the corporate form or from skirting around contractual obligations. None of those are present here. In the facts, the fraud has not been alleged, and therefore that test should not be able to be implicated here. Additionally, it raises public policy concerns. Going to MEDX's level of ownership is the most realistic and reliable test for international arbitration jurisdiction, primarily because companies that are seeking to invest in host countries that are subsidiaries can rely on the ownership of their parent companies as foreign control to establish jurisdiction. If we were to take the test that respondent advocates and move beyond, there are concerns as addressed by Mr. Arbitrator's question as to how far do we go. It essentially presents a moving target for jurisdictional questions. Shares of parent companies are available to and apt to change hands regularly on markets. So, for example, one could perceive a situation where, based on shareholder nationality of the parent corporation, international arbitration is effective. However, those...
So, I'm sorry to interrupt you, so that you say that you stop at MedScience?
Yes, correct.
Okay, thank you.
Yes, well, not at MedScience, at MedX. Yes, correct, at the first one.
Picking up what you just said, I mean, you say the ownership may change, but that could happen at any level, couldn't it? So, I mean, that's not a reason to stop in the first level?
Certainly it could. However, it's more likely to happen in the nature of shareholders rather than parent companies.
So that, wouldn't that mean only that you have to look at what kind of company it is, whether it is a public share corporation or some limited company, and that would make the difference rather than the level?
That is a concern, because if it were not a public company, there may not be a concern or a need to consider the nationality of the shareholders. But as pointed out in Tokyo Stotelos, as well as the PT Amico and Autopista, the tribunals declined to move beyond the first level of control. And that was supported by the reasoning that Professor McLaughlin has used, where he stated that typically ICSID tribunals had looked to legal control rather than actual exercises of operational control to determine foreign control for jurisdiction. So here, the 100% ownership would be sufficient. However, in the alternative, if we were to look for even operational control, that is established by MedX.
Well, I was going to raise that actually while you were talking about it. I mentioned it now, so you can react, and perhaps you can pick it up shortly in your rebuttal. Both of you refer to plenty of other decisions, and my general question would be, how relevant are they for us?
They are certainly not binding on this tribunal. However, they are very persuasive in showing the typical...
Some are. You always find those persuasive which are in your favor, aren't they?
Correct. Those are hopefully more persuasive than others. But it indicates the typical practice of ICSID tribunals, as well as the intentions of the ICSID Convention. And in Wiener Hotels, the tribunal stated that the purpose behind Article 25(2)(b) was to expand jurisdiction, to broaden the nets of jurisdiction so that individuals had access to dispute resolution forums, and rather it should not be taken in a restrictive manner as a respondent is attempting to use it here.
May I ask a question on that?
Yes.
Does it make any difference here that your client could have brought a claim on behalf of MedX, but it chose not to, and because of that particular litigation strategy that you've adopted, that's put the issue of control and reliance on 25(2)(b) into play? Given that background, is that not an argument why we should take a broader approach to looking at control and move beyond that first level of parent company?
No, not necessarily. You are correct in that is a possible strategic option. However, simply because that option exists, that does not mean that the option chosen is improper or that the criteria of Article 25(2)(b) have not been met. And respondent also mentions vacuum salt versus Ghana. In that case, the tribunal stated that while no particular percentage of ownership was required, 100% ownership almost certainly establishes foreign control. So here, as I mentioned previously, the operational control is also present. Respondent mentions the 2 employees for MedX. Those 2 employees sit on claimant's 3-person management board. So MedX employees exercise 2/3 of the control over claimant's management board. Those MedX employees would always have a majority vote. So there, they would have the power to decide operationally how it was run. So here we have legal control as well as operational control under MedX. Moving to the second requirement of Article 25(2)(b), the agreement. There is no indication that express consent or express agreement to treat claimant as a foreign national is required. And here we have a strong case of implied consent. And that implied consent is present for two reasons. First, as indicated by question 59 of the clarifications, MedX's ownership of claimant was at all times present and available on Burgonian's corporate registry. Thereby, Burgonian was on notice that MedX was a conveniencing national and owned claimant in this matter. Also, as we typically see, host countries are free to impose additional constraints or requirements on investors or on companies within their borders for them to be treated as foreign nationals. None of those things were done here. So because Burgonia was aware of MedX's holding of claimant and no additional requirements were put into place, there is a strong case for implied consent. This would meet both criteria of Article 25(2)(b). However, for the sake of argument, in the alternative, the most favored nation clause, as operating under Article 3 of the Burgonia Conveniency Bit on page 8 of the record, also establishes an agreement to treat them as a foreign national. Article 3 promises more favorable conditions if they can be found elsewhere by an investor. In this case, Article 6, Section 8 of the Burgonia Tertia Bit Agreement sets forth those more favorable conditions by agreeing to treat claimant as a foreign national because of their being considered a national of conveniencia and because of the foreign control.
Sorry to interrupt you again, but could you perhaps address Ms. Soltnikova's point that the language here is actually narrow compared to other most favored nation clauses?
Yes, the language here is certainly different than other most favored nation clauses. However, the examples pointed to by respondent are not in the exclusive list. There is a description of treatment less favorable, however, it states in particular that it's not considered exhaustive. So those things are not, the procedural matters are not explicitly outside of the bounds of the most favored nation clause. And also implicit within the promise of protection is the idea of access to forums. And here, most favored nation clause is used, again, in the alternative, to establish foreign control. And foreign control and the agreement touch both economic or substantive matters as well as jurisdictional procedural matters. So the two are so intertwined that they should be considered as being under the overall promise of more favorable conditions. But again, the claimant believes that Article 25(2)(b) was met even without the most favored nation clause. Moving on to my second point, the claimant's operations and uses of Burgonian patent number AZ 2005 constitute an investment. We see within the Burgonia Conveniency Bit on page 7, Article 1, Section 1, and specifically letters D and E, give us a definition of what Burgonia considers to be an investment. In letter D, it states intellectual property rights, in particular copyrights and patents. And essentially, is named explicitly. It can't get more clear than including a patent as an investment here. And further, in letter E, the fact that licenses conferred under contract are protected as an investment, which is precisely what claimant did with BioLife here. They licensed the use of their patent to BioLife under a contractual agreement. And both...
I just want to be clear, what is the actual investment that you say has been, there's an issue here? Is it just the patent right, the bundle of rights that come with that? Or are you talking about something broader than that? You're talking about a license now?
Yes, it is essentially all of the above, because both are included here. It is not only the rights to use the patent, the holding of the patent, but it is also the actual use of the patent. It's licensed to other companies, to other Burgonian companies, that then stimulate the Burgonian economy with it.
I can ask a follow-up question.
Sure.
Isn't it correct that, in fact, the BioLife license had been terminated by your client prior to the alleged expropriation? So I'm struggling how that can be part of the investment issue.
Sure, it was terminated. However, that does not prevent the prior use from being considered an investment. And the uncontested, or the clarifications also indicate that though in limited quantities, after the termination, Burgonia continued to make the product available and continue to use the patent themselves. And so the continued use, whether it was by BioLife or on their own illustrates the investment. And under the doctrine of lex specialis, the specific language within the Begonia convenientia that should be allowed to control, and as patent is defined, as well as license under contract, and claimant's operations proceeded, those should be considered an investment.
Well, let me just slightly following up, inquire again, what is the investment in our context? And probably we may have to raise that question both in the context of jurisdiction later on with regard to expropriation. I understand you to say that even though the contract was terminated, earlier we had an investment and that is sufficient. Later on, let me warn you already, we will have to deal with the same question for expropriation, and there the question comes up whether something, then you have to expropriate something which is still existing.
Sure, and let me clarify. I apologize if I wasn't clear initially. The previous use of the patent is a form of investment. However, after that license agreement was terminated, claimant continued to use the patent themselves to produce the product. So they had an established business, an established production, and an established sales. So those practices, in addition to their previous conferring the license under a contract, are what constitute an investment. And specifically, in CMS Gas versus Argentina, the tribunal stated that applicable bid agreement definitions are sufficient for jurisdictional matters when determining whether or not an investment is in place. And so not only do claimants' operations of making the product, selling the product within Begonia on their own constitute an investment, the fact that it's explicitly mentioned in Article 1 make it an investment because this is a jurisdictional matter. Because Article 25(2)(b) has been met through foreign control and agreement, and because claimants' operations and use of Begonian Patent AZ number 2005 are met, jurisdiction is proper in this case. Thank you, Gil.
Sorry. Honorable members of the tribunal, actually have one point to rebut. And first I would like to start with the case law, and that is quite right, which is not bounded for you. And during analyzing the case law, we try to find a logic which was similar in that tribunals and to show it to the present tribunal, try to rely on this logic and so on. For these purposes, we cannot try to rely on the present case on top of Stakeli's case, since the facts of the case was quite different. The Lithuanian company had a subsidiary in Ukraine, there was the dispute with Ukraine and so on. What is of great importance that ratio persona principle was based on other provisions of exit conventions, not the same which in the present case. And now it is also my second statement with respect to foreign control. In every particular case, there should be a sufficient grounds to prove the foreign control. For example, in Aquas Deltanari case, the control was proved by claiming by reference to both millions of the company and other evidence proving that decisions were made at the level of the Dutch company, the parent company in the present case. For example, in Amte case, the Latvian parent company of Ukrainian claimant possessed significant assets in Latvia, regularly conducted business there, and had projects under development of Latvia. In the present case, we just have this 100% of shares. However, there is no mathematic formula which allows us to say that there is or there is no foreign control. Also, we have some common phrases that there was 2 employees, there was subsidiaries, yet there was 2 members in the board of directors. However, there is no evidence that the decisions were made by Medic's company. Thank you for your attention.
Yes, Mr. President, briefly, 2 points. Just to make clear claimant's position, claimant is not relying on or analogizing the facts in Tokyo Stakeli's, simply using the reasoning that was present there as well as autopista and PTM code that piercing the corporate veil and moving beyond is only done in instances of fraud, which is not alleged here and which is not present in the facts. And also, as to my second point, to move beyond presents numerous problems, and it becomes an impractical and difficult to implement test It also flies in the face of the purpose behind Article 25(2)(b), and that is to expand jurisdiction. And because Article 25(2)(b) is met, jurisdiction is proper.
Thank you. I'm tempted to say something about Autopista, but because I was involved myself. All right, we now turn to the merits. And please start, please.
Thank you, Mr. President. Mr. President, this honorable tribunal, my name is Jonathan Matthews, and will be representing claimant discussing the merits today. Burgonia's interference with Medberg's investment amounts to an expropriation for 3 reasons. Firstly, expropriation in this case was a breach of Article 4.2 of the Burgonia Conveniencia BIT. Secondly, the exception listed in Burgonia Conveniencia BIT has not been met in this case. And thirdly, the compulsory license violates Article 31 on trips. As to my first point, if I could direct the tribunal's attention to the language of Article 4, Section 2 on page 9 of the record, the Burgonia Conveniencia BIT. Specifically, this article states that neither party shall be subjected to either measure the effects of which would be tantamount to expropriation. In this situation, a compulsory license can be considered a form of indirect expropriation. The learned scholar Correa, as well as Professor Christopher Gibson, have laid out a factor test when determining whether or not a compulsory license can be considered an expropriation. They suggest that tribunals look to the permanence of the character of the interference, as well as whether there was a substantial interference and the legitimate expectations of the investor. Here, the interference was for a period of 48 months, just at 40 years. The tribunal in Metalclad found there was an interference of 3 years that constituted an indirect expropriation. Additionally, the tribunal in Winier Hotels found that an act of interference which lasted just over a year amounted to an expropriation. Burgonian law allows the extension additionally if they want under the compulsory license. So in reality, this could move on past 4 years, potentially. They also suggest tribunals look to how substantial the interference is. Just because the claimant retains ownership of the patent, this tribunal can still find expropriation in the form of indirect expropriation. Here, Medberg owned the patent. They took the time to do the research and development, and thus should enjoy the fruits of its labor in receiving the ability to decide who has its patent and to extinguish those patents if need be.
Just on that point, just to be clear, though, at the time of the alleged expropriation, there was no existing license agreement, is that correct?
At the time of expropriation, that is correct.
So at that time, your client made a decision not to enjoy the fruits of its labors?
Specifically in Medberg, the claimant chose to terminate this license agreement with BioLife because BioLife had violated the terms of their exclusive agreement by exporting outside of the borders of Burgonia. It was for this reason, the threat of parallel exports, that the claimant terminated this agreement. Again, the claimant should have the ability to do that and to decide which companies make use of their patent because of the threats of parallel exportation. If I may move to my second point, the Burgonia Conveniencia bit provides an exception for expropriation. However, the requirements under the Burgonia Conveniencia bit for this exception are not met in this case under the facts here. Specifically, the language requires that for a state to expropriate, it must be for a public benefit, it must be non-discriminatory, and against prompt, adequate, and effective compensation. Here, it was not for a public benefit. Namely, obesity has been a long-standing issue within Burgonia, and it is not an emergency crisis, as the respondent would have you believe. 1/3 of the population was obese in Burgonia. Obesity is known to be caused by many factors. It's a complex issue, namely by genetic makeup and diet. The World Health Organization has confirmed that the best way to treat obesity is by making changes in diet and health-related physical activity, not necessarily by granting or using an anti-obesity product. Additionally, government acts which increase revenues in a limited number of companies should not satisfy the public benefit exception as listed under the bid. Here, there was the companies that had been making the compulsory license were in fact making 155% more sales than was being made under the exclusive license with BioLife. Additionally, the bid requires that the expropriation be non-discriminatory. Here, the compulsory license was discriminatory because the state treated Medberg differently than it did others. There, in fact, were other producers of the product or of similar products within Burgonia at the time, but claimant was specifically targeted for its product, and they had also granted other compulsory licenses in the past. The last requirement that has not been met was that it was not followed by prompt and adequate compensation as required under Article 4.2. Offering fair market value is an attempt to place the patent owner in the same position monetarily that it would have been had there not been a compulsory license. It explains more on this point and states that the compensation shall be equivalent to the value of the expropriated investment immediately before the date on which the expropriation took place. Here we have evidence of the value by what the claimant had made under its exclusive license with BioLife. What has been offered by the respondent is moderately lower than what they had previously been receiving under the license with BioLife, which is the best way to measure what the economic value of the patent was at the time immediately before the compulsory license.
May I ask a hypothetical? If the government offered your client a license fee that matched exactly that which was being paid to BioLife, or BioLife was paying to your client, would that cure the expropriation?
Well, if they offered exactly what they had previously been making, it would indeed satisfy this requirement under the bid. However, the other requirements would not be met, specifically that it would be for public benefit and non-discriminatory. Additionally, the language suggests that it be in accordance with applicable law. The facts indicate that Burgonia has adopted the same requirements of Article 31 of TRIPS under the World Trade Organization's framework for granting compulsory licenses. Because Burgonia has adopted this measure, the tribunal may look into the requirements of Article 31 TRIPS in deciding whether the compulsory license was lawful.
Let's pick up, get back on one point. The discriminatory question. It seems, how do you see in the context that the claimant was not enjoying the fruits of the patent because BioLife, because of the dispute with BioLife? Why would it be discriminatory under those circumstances for the government, through its patent office, to say, well, let's have compulsory licenses, so that the product does get developed and used?
Right. You've presented two issues here. I will address them in turn, Mr. Arbitrator. Firstly, as to the issue with BioLife, the claimant terminated the agreement with BioLife because parallel exports were indeed happening, and the claimant needed to control its product in order to make the most out of its investment in Burgonia as well as internationally. As to your second point, in the discriminatory nature, it is the claimant's position that the compulsory license was discriminatory because the claimant was targeted in the situation where there were other Burgonian national companies that could potentially create a similar product under the circumstances. Moving on to my last point, the license agreement violates Article 31 of TRIPS. Burgonia did not comply with the TRIPS requirement, firstly because it failed to make reasonable efforts to negotiate with Medberg before granting the compulsory license.
Sorry to interrupt your flow, but can I just be clear, what is the relevance of Article 31 of the TRIPS to the decision that this tribunal has to make? First part of the question. And the second part, despite this, my very distinguished colleagues on the panel here, are we the right people to be deciding an issue which is usually brought to a WTO panel of experts who deal with trade law and intellectual property issues?
Right. As to your first question, the reason why it is appropriate to analyze the TRIPS requirement in this tribunal today is because the language of the Bergonia Conveniencia bit under Article 4.2 requires that before an expropriation takes place, that it has to be in accord with applicable laws of the latter contracting state. The second set of clarifications clarified that Bergonia law has adopted the TRIPS requirements. So as such, this tribunal can go through the requirements of TRIPS, and if it is violated, then the international law has been violated, and the compulsory license would be unlawful. So it's through the bit that it comes in. Yes.
And the second part is competency.
As to competency.
Are we the best people to be dealing with issues of WTO law?
Well, the WTO does have its own method. However, this tribunal is the best to determine the language of the bit. Because there is a Bergonian Conveniencia bit which incorporates TRIPS, this is the best location to determine whether or not it has been complied with.
I understand your argument that this is part of the domestic law, TRIPS being incorporated. But could it be that you have a conflict between provisions of a bit and TRIPS, of what is permitted and what is not permitted, and how would you deal with it? I'm still not sure whether that is our case, but it might be our case, and then we'll have to deal with it.
Right. In the case that there was a conflict, it would have to be dealt with. However, the language of the bit has certain requirements that this tribunal will look at, namely that the expropriation would have to be for a public purpose, non-discriminatory, against prompt, adequate, effective compensation. Another requirement is that it be in compliance with applicable domestic law in Bergonia. The domestic law in Bergonia adopts the TRIPS language. So to that effect, this tribunal could look at...
Well, let me specify my question. If you look at the compensation to be offered under the bid in order to make the expropriation, if you look at the measure for that, and then you see a certain measure under TRIPS on how a compulsory license should be compensated. There may be a different measure. And then you do have a conflict, and I wonder how you deal with it.
Right. Well, to the extent that this tribunal finds that compensation has been inadequate under the bid, it may stop there. Additionally, if this court looks to the language of TRIPS providing more protection, that would also be applicable for the claimant in this situation.
I'll take it on it. Okay.
Just finishing the TRIPS analysis, TRIPS Article 31B specifically requires that before a compulsory license is granted, the party must first make reasonable efforts to negotiate. Article 31B requires this. There's insufficient evidence here to show that Medberg refused to negotiate. Additionally, none of the Bergonian entities which were given the compulsory license attempted to negotiate with the claimant before using their patent. Secondly, the negotiation requirement was not waived here by Article 31B because of the national emergency. National emergency is defined as a situation of crisis or emergency which affects an entire community and threats the entire population, as the tribunal found in Lawless versus Ireland. TRIPS additionally defines national emergency as may include a public health crisis, including diseases such as AIDS and malaria. But again, here, the issue of obesity is a far cry from such epidemics such as AIDS and malaria. In LG&E versus Argentina, the tribunal found there was a national emergency when there was a combination of factors, including high unemployment, a nearly collapsing healthcare system, as well as a declaration of nationwide emergency by the government. Here, there was no declaration of nationwide emergency, and other factors were not available as well. In Article 31F of TRIPS, requires that the compulsory license be predominantly for the use of the domestic market. Here, under the compulsory license, there have been multiple exports to countries outside of Burgonia. This is clearly flies in the face of the specific requirements of Article 31F. The respondent made mention that Article 31 bis, the amendment to Article 31, may apply in this situation, which loosens the requirements of Article 31F. However, Article 31 bis requires that countries importing outside of Burgonia must have a legitimate need and be developing or least developed countries. Here, the facts indicate that only one of those countries was a least developed country. Additionally, Article 31 bis, for the exception to apply, those countries under the amendment must have limited manufacturing capabilities. The facts and clarification show that these countries, in fact, did have some manufacturing capabilities. The last requirement under TRIPS that I'd like to discuss today is that of Article 31I, which requires, for a compulsory license, there must be independent judicial review. Here, the Patent Review Office, which reviewed the compulsory license, was actually created by the IP Office within Burgonia. Article 31I requires that for judicial review to be met, there be a distinct and higher authority. In addition, the judges that were on the Patent Review Board were in fact paid by the IP Office and by Burgonia. So in that fact, it was neither distinct nor a higher authority. Burgonia has expropriated Medberg's investment under both the BIT as well as international law, and we request that this tribunal find that there was expropriation.
Thank you very much. Return to respondent.
Mr. President, distinguished members of the tribunal, good afternoon. My name is Anton Petrov. I'm the second counsel for the respondent in this matter, the Commonwealth of Burgonia. In the next 15 minutes, I'll be addressing you with the substantial issues of this case, and this is expropriation and alleged violation of the TRIPS agreement. Now, this is the case of reasonable governmental activity which is fully compliant with both international law, BAT provisions specifically, and the TRIPS agreement, and is specifically necessitated by the domestic medical problems of Burgonia. Now, before turning to the core issue of this case, and this is expropriation, we would first turn to the issue of TRIPS agreement. Now, the claimant has referred to the TRIPS agreement in a very interesting way. It refers to it like as if it would be an international obligation of Burgonia towards the claimant because of the provision of the BAT concluded between the Conveniencia and Burgonia. However, the only way in which the TRIPS may be applied here is under MFN clause. In certain BAT, it is specifically stated that in Article 3, Paragraph 4, that measure which is carried out in accordance with the TRIPS agreement is not prohibited under the BAT. Now, this is the only way to invoke the TRIPS agreement, and in fact, MFN clause is something which the claimant refers to. In questions of compensation, it says that compensation should be equivalent to the fair market value. Now, this is the provision of the 13 BAT, not the BAT between the respondent and Conveniencia. So, if the claimant likes to invoke the provisions of the compensation that it should be equivalent for fair market value, then it should invoke the MFN treatment. And in these circumstances, it will face the problem of the TRIPS agreement, that if the measure is carried out in accordance with the TRIPS agreement, then there is no expropriation. And we have the firm position that here the measure was in accordance with the TRIPS agreement. Now, the TRIPS agreement here should be applied should be interpreted in accordance with the Doha Declaration. It has specifically stated by the dispute settlement body in Canada Pharmaceuticals case, in WTO, in Canada Pharmaceuticals case, that Doha Declaration is an agreement by the WTO members with regard to the interpretation of the TRIPS agreement. Now, the Doha Declaration specifically states that an agreement can and should be interpreted and implemented in a manner supportive of the WTO members' right to protect public health and in particular to promote access to medicines for all. And it specifically says as well that each member has the right to grant compulsory licenses and the freedom to determine the grounds upon which such licenses are granted. It also states that the WTO members are free to determine the grounds for national emergency and other cases of extreme urgency. So we submit that the Doha Declaration gives a very wide margin of appreciation of what is the purpose for issuance of compulsory licenses in accordance with the TRIPS agreement. And in this sense, it is.
Can you just help me when you cite the Doha Declaration in relation to the TRIPS, which prevails if one goes further than the other? And the Doha Declaration really goes further than conditions that TRIPS itself provides?
We of course defer to the conditions of the TRIPS agreement. However, we submit that here the TRIPS agreement should be interpreted in favorem the respondent, and this is mutatis mutandis what has been said by Professor Dolzer with regard to the BATs, that BATs should be interpreted in favorem investor because of the preamble under the Vienna Convention on the Law of Treaties. Now, to that, this is a presumption. We established a presumption that the provisions of the TRIPS agreement should be interpreted in accordance in a manner supportive to the WTO member, the respondent. Now, as to the specific conditions of the TRIPS agreement, specifically the claimant referred to Article 31 with respect to the negotiation provision and with respect to predominant domestic supply provision. Now, negotiation provision states that it states that the proposed user of the compulsory license should negotiate on the merit of obtaining the license. Now, here we have the fact in the record that the claimant itself has terminated the agreement with the licensee in the territory of Begonia, and it is also specifically stated in the record that the claimant had no intention to issue licenses in the territory of Begonia. So, practically speaking, there was no prospect that anyone from the proposed users of the compulsory license could be successful in negotiations. And moreover, even if the tribunal decides that this condition is nevertheless not complied with, it may be waived under the conditions of the national emergency. This was stated by the claimant.
Before you come to that, may I just inquire, when you refer to the termination of the agreement by the claimant, by the license agreement, do you mean to say that it is irrelevant for which reasons it was terminated? The simple fact that it was terminated and therefore the license drop is sufficient? Or don't you have to consider why it was terminated? If we heard it was terminated because there were experts and so on.
Well, it is very hard to consider why the license agreement was terminated. It is better for the claimant to answer. However, there is no fact in the record why it happened, and so every presumption here would be speculation and facts. We have the fact that this agreement has been terminated, and that's all on the facts of this case. Now, with regard to the waiver of the requirement of negotiations, it is stated that it may be waived on national emergency. Now, here we have national emergency, and under the Doha Declaration, and this is the application of the Doha Declaration here, we may establish that here we have national emergency. This is our right under the Doha Declaration.
Again, would you feel the Doha Declaration authorizes a state to choose whatever it likes and call it an emergency?
Well, of course not. Of course not. Of course, however, the practice says that in cases of such diseases as, for example, heart attacks, acquired diseases, the state may issue compulsory license. So it's not only for example, epidemics, as stated in the double declaration, but other diseases. And here we have obesity. We submitted this was the very serious problem, and it is the fact in the record that it became more acute at the time when the license has been issued. With respect to the predominant domestic supply, well, predominant domestic supply is a very subjective category. What is predominant? With again applying the double declaration. Now, predominant may be, for example, 51%. At the same time, we have the fact in the record that we have significant exports. Significant may mean, for example, 49%. If this hypothetical would be the case at hand, then we win on this condition, and there is no additional fact in the record in this regard. So we may not presume that here we have a violation on the part of the respondent, since we should apply the double declaration. So on this regard, we submitted there is no violation of the TRIPS. The measure has been issued in accordance with the TRIPS. However, therefore the claimant will win. The respondent will win on the merit of substantial issues. However, shall the tribunal decides that we should proceed to the VAT, whether the core question of this case, whether or not here we have an expropriation.
May I just interject again? I would like you to deal with that in your short rebuttal as well. The compulsory license authorization in TRIPS is, I suppose, an exception to the normal situation. And if that is so, who has the burden of proof for the facts that such a situation exists?
We submit that the burden of proof is on the claimant, as with regard to general facts and with regard to the specific question. And again, we have the presumption that the state acted in good faith in issuing this compulsory license, and this is the expression of Bergonian sovereignty. We submit that here the burden of proof is on the claimant. Now, what is with regard to compensation, with regard to expropriation? Now, here we have the key fact here is that here we have the law which has been adopted in 1997, long before the patent has been issued. Here we have the law which by itself limited the patent when it was already issued. And therefore there is nothing to expropriate here. The law has already at that time effective, and in this sense, it is not only the common sense but also the cases. Methanex case and Feldman case, other cases with regard to the regulatory actions of states. It is specifically stated in those cases that if we have the regulatory measure, then even if it somehow affects the property rights of private investors, it is not an expropriation. And this is exactly this situation. It is different from the Iranian cases, where there is also law on expropriation, because at that time there was already an investment, and then the law has followed. So this is a different situation. And this is actually the core problem of this case, that here we have nothing to expropriate. The patent has already been limited. Now, turning to the test of expropriation, the test has been established in Metal decision, rightfully has been stated by the claimant. The Metal decision cited Starrett housing case. In Starrett housing case, it was stated, and this is the general seminal test in the investment treaty arbitration, that if we have the interference within the rights of the investor to the extent that these rights became useless, this is an expropriation. Now, the question is on the facts, whether or not we have here an expropriation, whether or not we have here useless patent. Now, on the facts of this case, we have a situation in which the claimant retained its opportunity to sell the patent, it retained its opportunity to make products under this patent, it retained the opportunity to license, the compulsory license is non-exclusive. Practically speaking, nothing has changed. And citing the case of Canada Pharmaceuticals, and Canada Pharmaceuticals the patent has been divided into specific rights: the right to make, the right to sell, the right to license. Now we have this, all this amount of rights are intact, and nobody can say, especially.
So I hate to cut you off in the sentence, but surely you agree that one of the key rights that comes with any patent is exclusivity. Surely that right has been interfered with here.
We submit that exclusivity is not an essential part of the patent, unlike the situation in, for example, Moot in Bonfarm, when there was a specific exclusive right which was violated by absence of the exclusivity. Now here we have the patent which may be licensed. If it is licensed, then it is not already exclusive in the sense that other people also can use the same technology. So we submit that this is not an essential for a patent.
Well, at the time of the alleged expropriation, there was no existing license in Begonia. Is that correct?
I'm sorry?
At the time of the alleged expropriation, there was no existing license in effect in Begonia, so in fact the claimant enjoyed an absolute exclusivity.
Well, it is factual. We are talking here about the rights. Now, the respondent had, the claimant had this right, retained this right to license. Now, very briefly, with respect to discriminatory measure. Now, with respect to discriminatory measure, we should establish the standard. The standard was established in Court Products versus Mexico. Like circumstances are determined by the specific feature which is terminal for the decision of the state. Now here, this feature is the effectiveness of the patent. It is specifically stated in the record that the patent was more effective than the other medicines within the country. It is on this basis that we submit that there is no discrimination because of the effectiveness of the patent of the technology. And finally, with respect to the compensation, if I may. Now, here we have the compensation in royalty. May I finish something?
Please finish.
Now, with respect to the royalty, there is a common practice of 153 states, members of the WTO, to compensate such measures as in this case by paying royalties. And we submit this is a common customary practice that should be applied in this case. Thank you for your attention.
Thank you very much. Please.
Honorable Tribunal, just 2 quick points on rebuttal this afternoon. Firstly, the respondent contends that the language equivalent to the value regarding compensation was not included in the Burgonia Conveniency bid. If I may direct the tribunal to that language in Article 4.2, states that, quote, such compensation shall be equivalent to the value expropriated. Not only is it included in the Burgonia Tertia bid, as respondent has suggested, but that language is also included and relevant within the Burgonia Conveniency bid. The second point I'd like to direct the tribunal to is that there is a concern here of parallel exports. In fact, there was parallel exports, and the reason why the agreement with BioLife was terminated was because there was parallel exports happening. This was shown in the second clarification, question 39. If I may, one last point in regards to the TRIPS requirement that compulsory licenses be predominantly for the supply of the domestic market. The respondent has invoked the exclusion under the Article 31 bis. However, Article 31 bis requires that those countries importing outside of Burgonia must be least developed countries. Here the facts indicate that only one of them was a least developed country. Thank you for your time.
Thank you.
If I may address the tribunal with this rebuttal. Mr. President, distinguished members of the tribunal. Now, unfortunately, I should address the questions of facts here. And now, a small correction with respect to the first point. The BIT, not Turkey, the BIT, which is directly applicable in this case, says that such compensation shall be equivalent to the value of the expropriated investment. The alert claimant said that here we have the provision which says equivalent to the fair market value. Now this is not so. They specifically applied fair market value during the round. Now this is the provision of Turkey and BIT. With regard to market value, well, market value may be measured by different things. And here we have the market value, which is divided into the specific payments in royalty. So this is not an allegation which says that we have an inadequate compensation. And secondly, with regard to the predominant domestic supply, even assuming that we have violated this agreement, this provision, and we importing illegitimate amount of product abroad. Now, the fact in the company, in the record, says that at least one country among those that are addressees of the products is developing country. Now, it is not stated what are other companies. The claimant tries to say that this fact gives us the opportunity to say that other companies, other countries are not developing, are not least developed. But this does not follow from the record. We should follow the record, and the record does not give us this fact. On these reasons, we submit that there is no grounds to say that here we have an expropriation. This is a legitimate governmental activity, and it was in full compliance with the international law standards. Thank you for your attention.
Thank you very much. May I ask my colleagues, is there any urgent question emerging out of what we have heard so far? We still have to raise.
I'll be able to speak tonight.
Good. Okay, thank you very much. On behalf of the tribunal, let me thank counsel. It has been extremely helpful what we heard from you. This brings us to the end of this hearing. We have a rather specific kind of arbitration, insofar as the decision of the tribunal will be announced during a reception. But I take it that this is an illustration of the good relationship that we have between the parties and their counsel, that they are ready to attend the common reception. Thank you very much.